ultimately the judge gets the final say.
Yes.
And we've had one case, the case where we acquired default judgment against the defendant, and we went to court because the defendant instructed a solicitor to apply to set aside the default judgment.
Yeah.
And the judge peculiarly,
oddly,
made a decision despite evidence showing, and by the defendant's own admission, that the address where the claim form. Do you want to?
Yeah, I mean, this
step in here.
I mean, yeah, I do, because I think there's a couple of points. I think on the whole, the judiciary in this country is excellent. We're very fortunate with it, in spite of recent examples by one of the higher courts in the country. But two, there is a shortage of judges, and they're getting family lawyers who aren't used to civil litigation being district judges. Now, in this case, there had been judgment in default, and I did a skeleton argument. So there had been judgment in default, and the defendant had applied to get the judgment set aside.
They had instructed a solicitor.
They had instructed a solicitor, whom, to be honest, was adequate, but didn't say anything in court other than what was in the defendant's witness statement. So nothing else. So he didn't add anything. But so the hearing lasted for about half an hour, and in my view, and I think the judge's view, the defendant was on very shaky ground. So for a judgment in default to be set aside, there are two ways it can be. If the claim form hadn't been served correctly, and second, if there's no real prospect of success. Now, the judge, having heard the evidence, I think, felt a bit sorry for the defendant, but knew that there wasn't any real prospect of success, and indeed, as it turned out, there wasn't. But instead of that, he says, oh, well, I'm overturning the judgment because I'm satisfied that the defendant didn't receive the claim form. Now, that wasn't an issue, because it hadn't even been taken up by the defendant that it hadn't been served correctly. Because correct service isn't a matter of whether the defendant received it or actually read it. It's a matter of was it sent to the correct address. And this was. And it hadn't even been argued that it wasn't. So the judge's decision was completely wrong, which is another trouble with small claims in a way, in that although there is a right of appeal, it's seldom worth it.
But in this case, it hadn't been allocated a small claims track as yet. It was an application to set aside, but nevertheless, the judge,
which would have made it even worse, actually,
that sat on the hearing was a district judge.
If it hadn't been allocated, that's even worse, actually, because if it is allocated to small claims track and you want to appeal it, it's still small claims costs.
Right. Okay. But in this case, which upset us even more, in terms of what was a very, to put politely, unusual decision made by a judge. He gave cost in the case.
Yeah.
Very odd to give cost. Explain that. Why would it be odd to give cost in the case?
Because it had been, we had served, it was the defendant's fault, as it were, that he hadn't read the case. So it was completely his application. So we should have had our costs paid, irrespective.
Yeah.
I think the cost, rather than cost in the case, should have been costs on either side.
Yeah, but he gave cost.
So he gave the wrong cost order. So he compounded his wrong decision on bad law with the wrong cost order.
And what is cost in the case?
You have to give my slight hesitation there, because I can't remember. The last thing I could remember about this case, I'm sorry, John, was that it was cost in the case.
Yeah, we were very upset.
So, you know. But I have had other cases since
ultimately, what was said was, you said to me, Carlo, the judge has made a terrible decision.
Yeah, it was, but it was two terrible decisions.
He's given costs in the case, yes. To which I said, well, okay, I've got to fight this now. I can't drop it.
Yeah.
Because the reason why we can't drop it is he's given cost in the case, which means that if we drop it, they're entitled to
But
costs.
I think, and
would you say, was that a fair comment? If we dropped it, they would be entitled to costs because it's costing the case. Whoever wins gets the costs.
No, if you dropped it, I don't. In this case, I think you're right, but in this case, it wouldn't have mattered because I think the solicitor, as well as the judge, was also confused because I don't think the solicitor had realised that he hadn't been allocated.
Yeah.
So it hadn't been allocated to the small claims track. So the solicitor, so the defendant would have been entitled to.
But costs in the case.
So what costs in the case means is that whoever wins at trial
gets costs.
Will get his cost paid by the other side.
Mm. But nevertheless, this is a small claims matter.
Yes, but it hadn't been, as you say, it hadn't been allocated. And
yeah. And that I said.
And this was pre-allocation. You see,
yeah,
but I don't think the solicitor realised the importance that this was before it had been allocated to the small claim.
And nevertheless, my conversation to you then was, I better fight this now.
And you did, and you.
And I did, and I won. I managed to get a settlement.
Yeah.
I got everything. I got a very good settlement because I was able to pinpoint the weakness in their case that was overlooked by the judge for the simple reason that he didn't even entertain whether the case had a real prospect of success, which he should have done.
But it also shows, I mean, it was a fundamental and rather basic mistake by the judge in saying that I am satisfied, and he had given no inkling that he was building up to all this. This came in his judgment out of the blue. He had given no inkling that he had found that the defendant hadn't read anyway, maybe hadn't even received the claim form. Therefore, he was setting it aside. That's completely wrong in law, and there hadn't been any argument or discussion about this because it was admitted between the parties that it had been served correctly.
It was a pleasure having you in today, Robert.
Thanks.
And education, some fantastic information you've shared with our viewers. If there's anything in this interview of interest to you, please do get in touch. Our telephone number will appear at the end of the video. Remember, please like, comment and subscribe.